So, good morning to everyone joining from New York, and good afternoon to everybody joining us from the continent. I am Zyad Loutfi, LL.M representative of the Cornell Intellectual Property and Technology Student Association, and we are thrilled to host today our second masterclass discussion of the year on intellectual property objectives in international investment agreements. Now, intellectual property and investment laws, as you know, are vitally important fields that touch on vast range of policy issues, as well as public and private interests, well beyond their core scope of application. And unsurprisingly, both fields have been developing rapidly over the past decades. The idea behind today's masterclass is actually to highlight and showcase the connection between intellectual property on one side and investment law on the other, and to delve into the thorny issues that arise out of this quite complex interplay. Now, before we start today's masterclass and before I present our speaker, allow me just to say the following. This is a very interesting topic, and I promise you nothing less than very interesting discussions, especially given that our speaker is, in my humble opinion, a leading authority on the subject matter, someone whom I've read a lot and someone whom I've learned a lot from as well, and I'm sure it will be the case for you all. Just a disclaimer before we start, the discussion today will be recorded and will be posted on our official YouTube page. And following the presentation, we will open the floor for a Q&A session. So please feel free to prepare your questions and send it send it through the chat option in Zoom if you prefer to do so. So our speaker today is Dr. Pratyush Upreti. He is an assistant professor at the School of Law of Queen's University, Belfast in the UK. He is also a fellow at Stanford Law School in the Transatlantic Technology Law Forum. Before his appointment as assistant professor, he held several research positions at the Faculty of Law of the University of Helsinki and the Max Planck Institute for Innovation and Competition Law. His scholarship goes beyond IP law, and his research received several awards across the years. He is also the author of the award-winning book, Intellectual Property Objectives in International Investment Agreements, and he has kindly accepted our humble invitation today to share with us his expertise on the topic. So, Pratyush, the floor is all yours.
Thank you, Zyad. Let me first share my screen. Can you see my screen? Yeah, can you see my screen, Zyad? Yeah. Okay. Okay, thank you so much. First of all, thank you so much for attending this webinar. And to start with, I want to thank Zyad and Laura and Cornell Law School IP and Technology Student Association for kind invitation. So in next 30 minutes, I will run through my recent book titled Intellectual Property Objective in International Investment Agreements. So I have divided my presentation in mainly 4 parts. I will briefly give the context, why I have written this book, what this book is all about, and what are the approaches taken in this book, and the audience targeted for this book, and what are the main arguments. I will explain 3 main claims of this book. So to start with, let me give you a context of intellectual property and investor-state arbitration, or the tension between intellectual property and international investment agreements. So to start with, in general, intellectual property is a territorial right. Intellectual property are enforced at the national level. So basically rights derived from the national system, and IP rights are enforced at the national level. And we have at international level, we have WTO dispute settlement. So a WTO member state can initiate dispute settlement proceeding against member states for non-compliance of TRIPS provision or for clarification of TRIPS agreement. So these are the two important forums where intellectual property rights can be enforced at the national system and at WTO dispute settlement. Until 2010, so there has not been a discussion about alternative forum to enforce intellectual property rights. So intellectual property are included in international investment agreements. So when I refer international investment agreement, I'm referring to bilateral investment treaties and free trade agreement. So if you look at the history of international investment agreements, intellectual property always featured in investment treaties. If you go back and see investment treaties before Second World War, intellectual property featured in investment treaties back then, which was referred as friendship treaties, friendship, commerce, and navigation treaties. So over the years, investment agreement also evolved. And then in early 1950s, we had bilateral investment treaties, and then free trade agreement evolved in 1980s onwards. So this international investment agreement consists of dispute settlement mechanism, which is often referred as investor-state dispute settlement. So in this investment agreement, intellectual property is included in the definition of investment. So there has been an attempt where investor tried to enforce intellectual property through investor-state dispute settlement. So what a multinational company or investor does is they exhaust the remedy at the national system, and they cannot enforce IP at the WTO because at WTO it's a state-to-state dispute settlement. So they look for an alternative forum where they could go beyond the domestic system. After exhausting the remedy at the domestic level, they enforce or they bring claims against the state under the international investor state dispute settlement provision in international investment agreement. So there has been three main cases, and this is an emerging area of research. So in Philip Morris versus Uruguay, Eli Lilly versus Government of Canada, and Bristol versus Panama. So all the multinational companies, they, after exhausting their remedy at the national system, they argued intellectual property as a form of investment and initiated this dispute settlement provisions under those investment treaties to bring or to enforce the intellectual property rights. So these investment disputes were initiated, as I said, in investor-state dispute settlement clause in international investment agreement, governed by International Center for Settlement of Investment Dispute, UNCITRAD rules under the World Bank. So in all these cases, particularly Philip Morris, Eli Lilly and Bristol versus Canada, and Bristol versus Panama, these cases were decided in favor of states. So there are two ongoing disputes, which is Ironson versus Canada and the Bain Corporation versus Saudi Arabia. So besides this ongoing disputes, the first three disputes, Philip Morris was the dispute arose after Philip Morris exhausted the remedy at the national system, where Uruguay introduced this plain packaging provision. And because of the plain packaging provision, Philip Morris right to use trademark was restricted, which undermined the investment made by the Philip Morris. In case of Eli Lilly versus Government of Canada, the Eli Lilly was not happy with the Canadian Supreme Court decision in terms of invalidation of patent. So to challenge the domestic Supreme Court decision, they initiated investor-state arbitration. And also in Bristol versus Panama, Bristol was not happy with the decision given by the Panamanian Supreme Court, which initiated the investor-state dispute settlement. So what is the challenges or what are the problems of this emerging intersection or enforcing intellectual property rights in investor-state dispute settlement? There are two main problems. The first is the way multinational company has brought these cases before investment tribunal. It could threaten the balance struck in international IP. Second, overall, there is a legitimacy crisis of investor-state dispute settlement. So when I say investor is threatening the balance struck in international IP, if you see the award of Philip Morris versus Uruguay, where decision was in favor of states. So basically, tribunal said that the state has a right to regulate in terms of public interest, but they should not exceed the normal regulatory power. And while exercising regulatory power, the state action should not go outside the accepted margin of change. So what is this accepted margin of change? So there is no clarity on this accepted margin of change. So the point here is, given that investment tribunal, where they frame the decision is so broad that that can be used by another multinational company to bring IP-related investment disputes in ISDS. So there has been cases where investors has threatened to launch ISDS cases to influence domestic policy. For example, it is reported that pharmaceutical companies in Colombia and Ukraine has threatened to file ISDS claims to block measures related to public health. So in a nutshell, scholars argue that intellectual property does not sit comfortably with investment law, and ISDS should or could result in a regime shift that tilts the balance towards stronger intellectual property protection. The second problem is legitimacy crisis, in a sense that there's ongoing reforms of investor-state dispute settlement, and many states has refused to endorse ISDS in international investment agreement, and which further highlights the legitimacy crisis of the system. And 83% of all exit cases were filed against developing countries. So again, just to sum up the legitimacy crisis of investment arbitration, I would like to emphasize a couple of quotes by Professor Marty Kaskinomi and Professor Sornanasan. So basically, these two important scholars have pointed out that ISDS is a transfer of power from public authority to an arbitration body where a handful of people would be able to rule a country that can enact law or not. So basically, it's a transfer of power from public authority to this arbitration body of arbitration, which would able to influence or influence domestic lawmaking. And Professor Sornanasan has argued that ISDS is built on accentuating one side of the picture of foreign investment, and he used the term law of a grade by referring to ISDS. In this context, what the book does is it provides the intervention with this book is it's an attempt to reconcile the tension between intellectual property and international investment law. So in past few years, the intersection or the understanding or debate has been quite focused on understanding this emerging intersection and relationship between IP and international investment law. And what this book does is aims to reconcile the competing objective of IP and international investment agreement. So I have used this word investmentization of intellectual property. So when I say investmentization of intellectual property, what I argue in this book is there's a shift towards, or I try to demonstrate the second transformation of international intellectual property. The first transformation was when intellectual property was linked to trade. And now moving ahead, there's a possible transformation of international intellectual property when investment is linked or equated to intellectual property. So by investmentization of IP, the book refers to a phenomena of IP setting aside its social objective so that the sole incentive rationale of IP protection becomes investment protection. And I introduce or I present two ways of investmentization. First is social sense of investmentization and economic sense of investmentization. The social sense of investmentization of intellectual property means IP losing its social function, and economic sense of investmentization, which this book belongs to, the second notion of investmentization, is a way to explore systemic integration of IP and international investment law by developing a framework that safeguards the objective of IPRs in international investment agreement. So book is more, it's not about the intersection, it is more about how can we resolve this tension, given that intellectual property law or intellectual property provision will continue to expand in international investment agreement. So how can we build a framework within international investment agreement to safeguard the intrinsic value of intellectual property or the objective of intellectual property? So the approach taken in this book is in 2016, of David Kennedy, who is a professor at Harvard Law School. His book, A World of Struggle, How Power, Law, and Expertise Shape Global Political Economy. This book has been quite, it's a very influential book, at least to my scholarship. So the Professor Kennedy argues or explains this narrative of who is an expert. So basically, he defines who is an expert and what is the role of expert in global political economy. So if you look at the intersection of IP and international investment law, so there are experts from both the field who are trying to assess the emerging intersection between IP and investment law. So expert in terms of IP and investment law consist of scholars, lawyers, judges, arbitrator, negotiator, among others. So from Professor Kennedy point of view, the opinion of these experts creates narrative that are self-content, self-regulated, and self-obsessed. In Kennedy's word, these narratives are world-making stories. So he gives a very interesting example of nation. In his opinion, public international lawyers view nation as states, whereas anthropologists view them as a culture and economists view them as a market. So the point is, the Kennedy remind us that an expert does not simply have a specialist knowledge, but rather view the world as how other professions sees it. So the book embraces Professor Kennedy view of expert or Kennedy position on expert. And so if you look at the book, it goes to the detailed history, evolution of both intellectual property and international investment law. So even though book reflects the story of an IP scholar, but it equally takes into account the principle and theory and practice of international investment law. And the book is targeted to lawyers, and particularly it is also targeted to government officers involved with trade and investment negotiation. So the book is divided into mainly 7 parts. After introducing the book in terms of the debate, the chapter 2 talks about the social objective of international intellectual property. So in this chapter, I look at the Paris, Berne, and TRIPS agreement to understand what is the social function of intellectual property embedded in international intellectual property. And then in chapter 3, I look at the intersection of property and investment and asset, where the intellectual property per se can be treated as a property or can be treated as an asset vis-a-vis investment. And in chapter 4, I argue or I examine whether intellectual property can be treated as investment. And in chapter 5, I talk about the role of national and international intellectual property in redesigning the definition of investment. And in chapter 6, I talk about domestication of investment regime. And finally, in chapter 7, I provide a normative framework to protect intellectual property objective in international investment agreement. So the book explores how to integrate social objective and bargain achieved through international intellectual property treaties in international investment agreement. The first claim is intellectual property should not be equated with investment. The second claim is, how do we reconceptualize investment? My argument is we can reconceptualize the definition of investment by bringing national limitation and exception related to intellectual property. And third, can we imagine sui generis IP exception in international investment agreement that safeguards the social objective of intellectual property rights? So to start with IP as investment, the starting point of enforcing intellectual property rights in investor-state dispute settlement is to treat IP as investment. As I said, intellectual property is included in definition of investment. So to pass the jurisdiction requirement, investor must show that any dispute arising out of investment. So that means any dispute arising out of IP as investment. So arbitral tribunal has developed this criteria to assess investment, which is known as Salini criteria. So there are four main criteria: duration, regularity of profit, risks, economic development in host states. So IP may fit within this criteria developed by arbitral tribunal, but my claim is intellectual property cannot be equated with investment. And why I say this, because the way investment is read, the definition of investment is read by investment tribunals is very different how we read investment in intellectual property system. So basically the intellectual property system provides incentive to innovate, right? It's a reward based on the investment made by the innovator through intellectual system. The exclusivity is given to the innovators so that they can benefit from the exclusivity and return the investment made to create that innovative ideas or patent or any form of intellectual property. So my point is, if IP is equated with investment, the fundamental presumption would be whether investment function is a part of exclusive right guaranteed by the protection of intellectual property. Because often investment is read as a property, or investment is read as a value or expectation. For example, many arbitral tribunals even treat market access as form of investment, right? So intellectual property creates value, but intellectual property exclusivity is not given for the value that IP creates. So not all intellectual property result in value creation, right? So economic value is not the part of IP exclusivity. IP may help to generate value, but that generation of value is not part of IP exclusivity. So why this is important? Because if you look at the nature of intellectual property, there is a limitation and exception to intellectual property rights. So if you see IP from purely investment and value point of view, as how investment tribunal would read investment, definition of investment, so that will undermine or give an impression to give an impression to the multinational company that the value that the IP generates is part of exclusivity. So if a state comes up with the regulation, for example, by using exception and limitation, if they undermines the value of that intellectual property, then for investors, they would treat that as an expropriation of property. And that may not be expropriation per se, but the moment you treat IP or equate IP with investment, then you also embed value created by intellectual property. So the claim is IP should not be equated to investment. And the second claim here is, how do we reconceptualize investment if we are not able to equate IP with investment? The starting point of this chapter 3, where I argue the role of national and international IP law and policy in reconceptualizing definition of investment. So why definition of investment is important? Because to start the investor state dispute settlement, the entry point of jurisdiction analysis is treating IP as an investment. So the first approach to reconceptualize investment definition is remodeling the content of intellectual property rights in investment definition by introducing the language of balancing principles as reflected in international IP. So, or we can have a negative definition of investment. So basically negative definition means some aspects of intellectual property is not part of definition of investment. So the point here is, moment we bring language of TRIPS, for example, if you bring the language of TRIPS, let's say exception and limitation provision into the definition of investment, so then arbitral tribunal would be forced to read those exception and limitation while reading intellectual property as investment. The moment they read intellectual property as investment, which is embedded with exception and limitation, the tribunal had to go back to the national system and how this exception and limitation are implemented in national system. So basically the idea is to bring back the jurisdiction of national practices into the investment arbitration by linking or modifying the language of international investment treaties by exclusively including the flexibilities of TRIPS into the language of investment definition. The third would be the approach taken by Indian model BIT or South African model BIT of 2015. So here, investment is defined as an enterprise constituted, organized, and operated in good faith by investor in accordance with law of the party. So enterprise is also defined and law of the party is also defined. So this approach will have this territorial nexus to the investment, so that state would control in determining an investment and can act as a gatekeeper to investment arbitration. So the approach of these three different ways to reconceptualize investment is basically we are integrating national limitation and exception into the definition of investment. And the third claim is imagining sui generis IP exception. So there are general public policy exceptions in international investment law, but my point here is we need to develop this specific sui generis IP exception. So the main idea is to create inbuilt restraint in the form of treaty language. So basically sui generis IP exception would act as a complement to general difference or general balancing principle in investment treaty arbitration. So in chapter 7 of the book, which is divided into two parts, in the first part, I look at the different balancing mechanism used by investment tribunal. For example, margin of appreciation, proportionality principle. And I argue that balancing principle in form of proportionality and margin of appreciation does not help per se to safeguard intellectual property objective. So there's a need to have a specific IP exception in international investment agreements. So the sui generis IP exception demonstrates internal treaty limitation on the scope of treaty obligation. So why sui generis IP exception? I think sui generis IP exception would reduce uncertainty and promotes predictability and estimation in investment arbitration. And basically the idea of sui generis IP exception is to bring back the flexibilities and the balance achieved through international IP into the international investment agreement. First, to identify what are the important balance achieved through TRIPS agreement, and then include those into the international investment agreement in form of sui generis IP exception. So To do this, I first mapped out investment treaties signed or which are in force between 2010 and 2019. So I found that 22% of international investment agreement signed and forced between 2010 and 2019 has a reference to TRIPS. So I found three kind of international investment agreement. First, some international investment agreement explicitly include TRIPS provision, and the second form of international investment agreement has opted for general language in reference to parties' commitment to multilateral agreement. And in some international investment agreement, there's no reference to TRIPS or general commitment to multilateral agreement. But in recent trade and investment agreement like EU-Canada Comprehensive Economic Trade Agreement or CPTPP, Comprehensive Partnership, Comprehensive and Progressive Trans-Pacific Partnership signed between Australia, Brunei, Chile, Japan, among others, and RCEP, which is a Regional Comprehensive Economic Partnership Agreement signed in 2020, and more recently, UK-Australia Free Trade Agreement, they have reference to TRIPS language. So in case of older generation, bilateral investment treaties or international investment agreement, they don't have specific public policy exception. So the point of this book is we need to have additional layer to protect intellectual property objective by creating this sui generis IP exception. So the challenge for me is what will be the content of sui generis IP exception. So TRIPS has so many provisions from preamble to flexibilities. So what will be the content of that sui generis IP exception? And then I use this idea of basic structure doctrine in intellectual property. So basic structure doctrine I adopt from Indian Supreme Court decision in case Varity versus State of Kerala. So the Supreme Court of India, while addressing the issue related to amendment of constitution provision, said that the Parliament cannot alter each and every provision of, they can alter constitution, but some of the basic structure of Indian constitution cannot be amended. So the doctrine limits power to alter or modify the constitution basic feature. So the point is, what is the basic structure principle? If the idea of drawing a constitution basic structure doctrine in IP to avoid fragmentation and to protect the intrinsic meaning of IP, the idea is to have this basic structure doctrine that would be treated as an IP exception. So to start with, we need to know what is so basic about international intellectual property agreement, because in terms of basic structure doctrine, the overall basic structure of constitution like preamble, for example, cannot be amended. So what are those basic structure of international intellectual property, in particular TRIPS, that cannot be amended, or that plays a vital role in reading provisions of TRIPS? Then I argue that Article 7 and 8 of TRIPS agreement can be treated as a form of basic structure doctrine in intellectual property. And what I do is I first locate the history of Article 7 and 8, how it evolved, and the importance of Article 7 and 8 established by WTO panel and appellate body, and which offers overall balance to intellectual property system. It provides fairness to IP system, and it strengthens the capacity of state to ensure global justice duties. So once I established the importance of Article 7 and 8, read with the social objective of international intellectual property, I treat Article 7 and 8 as sui generis exception in international investment agreement. So the point is treating Article 7 and 8 as a basic structure doctrine, then transplanting that Article 7 and 8 in form of sui generis exception and have a specific provision in international investment agreement on Article 7 and 8. So the importance of this having an additional layer to safeguard intellectual property objective in international investment agreement is arbiter tribunal are forced to read Article 7 and 8 while adjudicating dispute in relation to intellectual property in investor-state dispute settlement. So this is a of course, arbiter tribunal needs to apply sui generis IP exception broadly, but also case by case. And I think the critique would argue that there are so many provisions why only Article 7 and 8 can be part of sui generis exception. But again, I think the point here is the starting point should be Article 7 and 8, and the sui generis IP exception can expand, because it's important to understand that the international investment agreement is signed by two sovereign states. Under Vienna Convention, they have power to amend or include any clauses within the international investment agreement. So taking into account that the state or developing countries can transplant the language of TRIPS going beyond Article 7 and 8 and creating that as an IP exception under the investment chapter of International Investment Agreement. So when there's a dispute arising out of intellectual property by treating IP as investment, arbitral tribunal need to read or decide that dispute, keeping in mind the relevance of Article 7 and 8, which is balancing principle of international intellectual property. So this approach will safeguard IP objective and also ensure legitimacy of investor-state dispute settlement. So to conclude, there are only few cases, 3 main cases, and two are ongoing. So this is the starting point of intersection of IP with investor-state dispute settlement. Difficulty will arise with new cases consisting of IP at the core of the dispute, and complexity is further added with every new international investment agreement, which may not carve out to safeguard IP objective. And the vagueness of investment principle and legitimacy crisis of ISDS will further affect the balance achieved in international IP. So the point is, can we think of making international investment agreement flexible so that intellectual property objective can be safeguarded by bringing flexibilities of TRIPS and by treating Article 7 and 8 as sui generis IP exception. So I conclude my presentation, and I'm very open to discuss in generally, if you have comment or if you have any point of clarification, I would be happy to respond. Thank you.
Thank you, Pratyush, for the interesting insights on the topic, and indeed the intersection between intellectual property and investment law and ISDS is quite new, and the topic is quite understudied, as we were discussing informally before we started the talk today. So we've touched upon very, very different aspects of this intersection, and I was wondering, let's first add, I'll remind the audience that if you have a question, feel free to raise your hand or use the chat box option. So to kickstart the Q&A debate, I'll ask a question that I have, and I want to know your opinion on that, because we've mentioned that there is a sort of regime shift that scholars dictated and explained when intellectual property was first apprehended as an incentive-based asset, and then when it was integrated into the trading system, we started perceiving intellectual property as a trade asset, and now we're moving into a third wave of purely perceiving intellectual property as an investment asset. And we've touched upon this regime shift, and I was wondering if you can tell us, or your opinion on the risks actually of apprehending intellectual property as a pure investment asset. And I'm sure I think we've touched upon it very briefly when you talked about the social aspects or the social functions of intellectual property, but I think maybe we can give this point a little bit of attention, and you can tell us your insights on it regarding the risks.
Yeah, I think that the challenge is, again, the legitimacy of investment status with settlement is very important. So there's an ongoing reform in UNCITRAL. So those reforms are procedural, because if you look at investor state dispute settlement, so it's an ad hoc dispute settlement body. So in some cases, arbitrator will wear the hat of as a judge. In terms of a lawyer will wear a hat of arbitrator. In some dispute, lawyer, that arbitrator will be arguing on behalf of the parties in another dispute. So the question is, even if there is a reforms in terms of procedural aspect of ISTS, the challenge is the substantive norms. So international investment law is not codified. So so sources of international investment law is bilateral investment treaties. So there are principles evolved through these cases on expropriation, fair and equitable treatment. So the challenge of enforcing intellectual property to investor state dispute settlement is the danger of reading intellectual property or treating investment protection as a form of exclusivity of intellectual property given under intellectual property framework. So in this book, I looked at many cases. So we often think that there are only 3 or 4 cases, but most of the investment disputes, the multinational company often refer to intellectual property in bringing the cases against the state, because the reading of intellectual property as investment and reading of investment as a value expectation by arbitral tribunal is quite different in understanding of investment in intellectual property. So intellectual property creates value, right? And intellectual property incentivizes innovation. And then there's a discussion about whether we are giving too much of exclusivity to intellectual property that hinders access to knowledge, access to justice. So keeping in mind the reading of investment within intellectual property is mostly from incentive to innovate, so which has economic angle as well as a social angle. But the reading of investment under international investment law by tribunals is confined to the economic sense, because the idea of investment treaties or through bilateral investment treaties dispute settlement mechanism is to create supranational like generative properties in force at the national level. So through investment dispute settlement. So it's a way to enforce this property right at the international level. But it's important to understand that intellectual property is rationalized on the idea of property, but there is also the social function of property, which also emphasized in terms of balancing rights and obligation. So having this treating IP as an investment per se, or equating IP as an investment, will undermine the social function of IP, because IP is not meant only to generate revenue. It is also about access and balancing rights and obligation. So the danger is, by linking IP and trade, we have a different system. By linking IP and investment, we might create a new form of a system where IP is enforced beyond the domestic system, and that would force state to change law in relation to or based on multinational companies' grade to say.
Great. Thank you for the detailed answer. I think we have someone who raised their hand. So Shreya, maybe you can just I can unmute you, I think.
Yeah.
Or you can. Perfect. Yeah, we can hear you. Go ahead.
Okay, I don't really have a question, Professor, but I really have to say that deriving inspiration from the basic structure doctrine was an ingenious move.
Thank you, Shreya.
Yeah.
So yeah, the doctrine that you've mentioned, it's derived from an Indian case that you've used and you've swayed it in your direction, as we have touched upon that. We have a question from Jacob in the chat. He is asking, what do you mean by global justice duties of states in the context of IP as investment?
Mm-hmm. Okay, so again, so in chapter 2, of this book, I first established what is the social objective of international intellectual property. So I looked at the propertification of intellectual property by using property as a narrative to incentivize innovation. So the idea of intellectual property is also access. The state use intellectual property as a system to innovate, but at the same time, that giving that exclusivity. And so often we read exclusivity in forms of monopolistic right, but that exclusivity has also another purpose. That is the purpose to access or to make sure that that invention is within the public domain. So I developed this idea of responsibility of states. So states create this IP system, not only incentivize innovation that society in general would promote, would be using that innovation, but the idea of creating this global justice duty through Article 7 and 8 is, if you look at the history of Article 7 and 8, it is proposed by India. And there's a lot of debate of how the treaty language was used. In fact, if you look at the early draft, so there was a use of, there were different terminology used, which were more inclined towards emphasizing social objective, in a sense that state has certain duties, not only to incentivize innovation, but also ensure that the access is equitable, right? So the point which I was referring to, Article 7 and 8, is all the provisions of TRIPS must be read through lens of Article 7 and 8. So Article 7, as I explained in chapter, has three main goals: development objective, social objective, and balancing tool. And given that, if we include Article 7 and 8 in investment agreement, arbitral tribunal are forced to read this doctrinal approach to Article 7 and 8. And that would also, and so arbitral tribunal would appreciate that in terms of intellectual property, state also has certain duties in terms of equitable access and balancing IP to ensure not only to incentivize innovation, but also to make sure that there's an adequate access of that technology or innovation to people.
Okay, so we've touched upon this interesting issue of developed and developing countries, and the fact that some of these international investment agreements are signed between, most of the time, developing countries and developed countries as well. Which brings me to a question that I had in mind when you were discussing it, which is, how can we safeguard developing countries from the harsh terms negotiated by developed countries through these international investment agreements? From my understanding, some of the FTAs and some of the BITs, they impose higher standards of protection, sometimes a longer duration of IP protection, which is quite paradoxical, because the same IP right or the same IP holder, let's say a pharmaceutical company from the US that holds a patent that is valid for 20 years in the US, but unfortunately that will be valid for, let's say, 25 years under the BIT, under the FTA with Jordan. Is there a way, or how do you perceive these kinds of trends in IP norm setting in general? And is there a way to safeguard developing countries from that?
Yeah, I think one of the it's really good and important question. I think the challenge for to break down the whole purpose of investment treaties, where so one side of the picture was having an investment treaties would allow transfer the technology to developing countries. So that's why they gave up in terms of certain treaty language, among others. But from 2015 onwards, particularly India, Brazil, they came up with the new model bilateral investment treaties. And if you look at how intellectual property landscape has changed, so countries which were in early 1990, which were importing intellectual property, are now can export intellectual property. For example, India, Brazil, South Africa. So what this country can do and also support other developing countries is creating innovative treaty languages and because if there's an agreement between developing and developed country in terms of investment treaties, for a developed country, a developing country is read from in terms of market access, right? So basically under Vienna Convention, this international investment agreement is signed between two sovereign states, and they can, and I think they can engage in these innovative treaty languages. That's why the book is also targeted to government lawyers and negotiators to think that it is possible to have this sui generis IP exception into the treaty languages, so that the social function of intellectual property, because the TRIPS provides minimum standards, and if you see the IP system in let's say US, EU is quite advanced, and the IP system in some of the developing country is developed in a way that benefits local and economic and social in terms of development of that state. So I think the reading of intellectual property is quite different. And if the developing country reads intellectual property from broad societal justice and embedding social function of intellectual property, probably creating those innovative treaty language in international investment agreement, probably would pursue even developed country, because ISDS criticism has not only has come from developing countries, even from developed countries. That's why there's an ongoing reform. So this is the right time to come up with this doctrinal approach and innovative treaty languages to pursue the government negotiated to come up with this new approaches. And just to conclude this on this point, so there are very interesting treaty languages developed by African Union in terms of IP protocol. So there they also have taken similar to sui generis approach in terms of traditional knowledge and other forms of intellectual property.
Okay, thank you for the for your insights. We actually have one last question that I received by an email from my colleague Gorsi Haj, since he had to leave for class. He's asking a question regarding the competence actually, or the jurisdiction, admissibility of the claims, and he's asking, to what extent can an arbitral tribunal interpret the IP treaties once declared that it has jurisdiction on the subject matter? So I think it's a complicated topic, but I hope that you'd have a less complicated answer for us.
Yeah. So I think the answer is, in principle, the arbitral tribunal cannot interpret, or they should not interpret international IP treaties. And that's a danger, right? That's why we are talking so much about IP and investor-state arbitration. So in Philip Morris and Eli Lilly and Bristol, arbitral tribunal never reached a point where they could read international IP treaties. So it's a really good point. We don't know in future investment tribunal might read and interpret. So that's a whole point, because TRIPS agreement provides so much of flexibilities in language. If arbitral tribunal reads TRIPS provision in a way that is quite inclined towards investors, that might undermine the space given to the state in terms of regulatory control of intellectual property. So in principle, arbitral tribunal should not. And there is a very interesting decision on ACMEA, and European Court of Justice of European Union have emphasized that arbitral tribunal do not have power to interpret the domestic laws. They can examine in terms of while adjudicating the dispute, they could examine the domestic law, but they don't have a power to interpret the domestic law. But again, there's also a difference between examining and interpreting. When you examine, you always interpret. So that point is not clarified, but this is one of the danger. And one way to embrace this IP exception, sui generis exception, is to forcing arbitral tribunal to not interpret IP treaties, but to force them to bring the national limitation and read the IP dispute in relation to the local practices rather than interpreting IP treaties.
Okay, so before we wrap up, would you say that you are more optimistic or pessimistic with regards to the future of IP, international IP laws?
Well, I think I'm quite. I think I work on global IP, so I have to be very optimistic in terms of how IP has evolved and it's evolving. I think the intersection of IP and international investment law, this is a very new topic. It has been almost 7, 8, almost 10 years now, but there are very few cases. So probably in moving ahead, there will be cases where intellectual property will be at the center of the dispute, and arbitral tribunal might interpret the international intellectual property treaties. So I think this is a very interesting discourse. On the other hand, there's also reforms going on ISTS. So probably we don't know how the reforms will be placed, but I can tell you that for multinational company, investment tribunal would be definitely an option to bring or at least threaten the developing countries to influence the domestic IP policy making. So there's a lot to do on this topic, and it is emerging, and probably it will evolve moving ahead. And also there are new bilateral investment treaties, innovative treaty language that also plays an important role. And so I think I'm very optimistic in terms of development, but there's more work to be done in terms of safeguarding intellectual property objective through international investment agreement.
Okay, perfect. So I think we can wrap up today's masterclass on this high note, and to stay optimistic and yeah, very looking positively for the future of intellectual property. And with that, actually, we can definitely wrap up. And on behalf of everyone at Cornell and at the Intellectual Property and Technology Students Association here, we are very grateful that you have accepted our invitation, and even more grateful that you've shared your expertise and insights with us all today. And yeah, one of the most engaging sessions. Thank you for that comment. And yes, we're very grateful for the time you spent with us today. And a quick reminder as well that the recording will be uploaded on YouTube, so it will be there for whoever, for anyone who had missed it. And yeah, we thank you all for tuning in, and thank you, Dr. Upreti, for joining us today.
Yeah, thank you so much for inviting, and thank you to organizers and all the participants for listening and engaging in the debate, and hope we keep in touch, and thank you so much.
Definitely. We'll make sure to keep in touch, and hopefully we'll talk about more about intellectual property and investment law in the next years at Cornell, hopefully with you as well.
Yeah.
So thank you.
All right.
Perfect.
Thank you so much.
Thank you so much.